Alex here with a video, a legal nuts and bolts video on the topic of meet and confer. There are, at least in Nevada, several places in the rules of civil procedure and at least one or two places in the rules of appellate procedure where you're supposed to meet and confer with your opponent's attorney. If you're representing yourself, you're your own attorney, and so you're going to have to meet your opponent or their attorney. Most likely, if you're on this channel, you're dealing with an opponent being an attorney or represented by an attorney. Yeah, this is a question that I get in my emails, how to deal with this. And it's especially a question that people have fears of saying the wrong thing, I guess, during the meet and confer. It's hard for me to give advice on this because even though I've done this a few times, there are a lot of questions that I'm getting that I don't have answers to. One of the questions is, do they record you? Can they record you? If they do record you, they use what you say against you? And I get where this is coming from because when you don't know much about the law, your fear is that the other side, which is probably an attorney, is trying to trick you. They're trying to trick you into saying something you're not supposed to say so that they can use it against you in court. That's the fear most people have. And it kind of freezes them up, makes them not want to do meet and confers, makes them want to do it, I guess, through email only. My understanding is that that's probably not going to work. If you have like a case management conference, that's really not going to work because I think even the judges go to those. Still somewhat relevant on this topic though. All I can do is tell you how I handled it and what I would recommend. First off, if you're worried about being recorded and your own words being used against you, I really don't know 100% for sure what the answer is on that. If you are supposed to meet and confer because a rule says so, they may be able to record you without you knowing. I don't know. Look it up if you would really like to. Um, my thought would be that just make sure that you speak to the other side in the way that you are being recorded, whether you are or aren't. Just think to yourself, it doesn't matter. I'm just going to act like I would act if I was being recorded. The other thing I'd like to mention is pay very close attention to the narrow scope of the meet and confer. One of the biggest, I think, mistakes non attorneys make is they go into those meetings super emotional because they're already going through a lawsuit with lawyers and they're by themselves and they don't have one and they are upset and they feel like they're being tricked and exploited left and right, confused. So they go into the meet and confer all on edge, freaked out, and probably saying things that they shouldn't be saying in the sense of they're going beyond the boundaries of the meet and confer. Maybe talking about the substantive issues of the case, upset about settlement offers or not getting a settlement offer. If the meet and confer is about setting a discovery schedule, then that's all you should be talking about at the meet and confer. That's it. As a rule of thumb, if you really think maybe they want to talk to you about settlement or other things, just err on the side of caution and send an email. You know, hey, separately, I'd like to talk about this. Hey, separately, I'd like to talk about that. Um, if you're going to a meet and confer on discovery scheduling, just talk about discovery scheduling only. Go through when the due dates are, what requests for admissions, what's the limit on them, when should those be due. Interrogatory, same thing, just go down the list, deal with that one particular issue and get off the phone. Don't make it out into more than something that it needs to be. Probably not a good idea to start going into the actual case itself, to start complaining about things the other side is doing. Just put that stuff into some kind of separate communication, totally separate communication. If you aren't really doing what you're supposed to be doing at the meet and confer, it is possible that the attorney is going to go back to the court and say, hey, they violated this rule. They didn't want to talk about these particular issues that we're supposed to talk about. We want attorney fees as a sanction. Now we need the court to schedule everything because they didn't comply. It's going to just backfire on you. It's just going to blow up in your face. So as upset as you might be about the case as a whole, as you know, especially if it's about things that are going on that the lawyers don't even have control over. So if you are dealing with a certain lawsuit that has the litigants themselves that are maybe sending you messages or acting out, they don't care. Those lawyers are there to deal with what the rule of civil procedure requires them to deal with, and that's it. They're not going to want to go beyond it in any way, shape, or form. I know I mentioned this at least twice in the video. If you disagree and you think they should deal with it separately. Send a separate email, call them on the phone separately. Don't mix all these other issues into a meet and confer because A lot of lawyers probably feel like they don't want to deal with a pro se litigant anyway. They probably don't want to call you. They probably want to email you as little as possible. They probably just want to steamroll you and move on. And so when they have to meet with you because of a rule, the last thing that they're going to want to do is feel like they're trapped there having to put up with all this other stuff because a rule requires them to be there. And I wouldn't be surprised if motions get filed after the fact expressing their frustration and wanting to punish you in the only way that they think they can, which is to take your money. So I think this hopefully helps people understand the importance of dealing with meet and confers in the narrow way that they're tailored. Check the rules, look at what you're supposed to discuss, only discuss those particular things, and move on. If you're worried about being recorded and it being used against you, just assume that you're going to be recorded. Just assume it and don't go all crazy saying, cussing them out, yelling, or just being obstinate. The rules require what the rules require. And that's it. So I think that's all I can really do with regards to meet and confers. I know that I've done at least twice two of these meet and confers. One of them that I can remember a little bit better, which was the one against Corazon Real Estate. I believe it was on some kind of early discovery exchange required by the arbitration rules. And I mean, that's all I talked about is how are we going to do discovery? I remember talking about whether or not discovery was going to be bifurcated between the punitive damages portion and the non-punitive damages portion. I remember that. And I just talked about that one particular thing, and it wasn't a big deal. I never had anything filed against me afterwards. We just got through it, and that's it. I do think that some lawyers who suspect that you have a ghost lawyer like to use these as an opportunity to find out if you do. And I guess if they're asking you inappropriate questions, just tell them, you know what, that's not why we're here. Or just say, I've already answered that. I mean, if they're saying, I guess if they're trying to like quiz you, what's an interrogatory? What's a request for, that's weird. They shouldn't be doing that's inappropriate. There's not a whole lot you could do about it. I mean, if you want, you can tattle on them, but I don't think the judge is going to care. I would just say, hey, we're just here for this. This is discovery. We're talking about these things. We're scheduling. Why are you trying to quiz me on the law? Why are you asking me about who my secret lawyer is? I don't have one. Move on. So I mean, if that's what if you're dealing with an attorney who thinks they're going to use a meet and confer to try and like find out if you don't know what you're talking about and somebody else is pulling your strings, just reaffirm to them that you're not and just get down to business. That's really the best way you can deal with that. If the lawyer thinks that you have a ghost lawyer and that you're just a schmuck and you're a puppet, the best way that you can show them that they're wrong is just show them that you have knowledge, show them that you're knowledgeable. No, we're here for, NRCP 16.1 sub 2.3 or 2C. And I don't know why you're asking me those questions. Can we get back to scheduling? That's all you can do really. So I guess that being said, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.